I'd like to welcome everyone to the RC Thornton Associates webinar on Proposition 206. Many of you know our host and moderator, Chuck Thornton of RC Thornton Associates. Along with being your tax expert, he has a large network of relationships with many professionals in various industries. Chuck will often host webinars through our speaker series on tax and also non-tax related issues that may be of value to your business. Chuck, I will turn the presentation over to you.
Okay, thank you, Kid. I appreciate you doing that fine introduction, and I'm going to introduce our speaker here in a moment. In fact, let me tell you a little bit about our speaker. He's no stranger. He's actually presented several items in the past for our clients and people that we know, such as shareholder restrictive agreements, employment restrictive agreements, and so on. But today we have a topic that is actually very time sensitive, and it has to do with everybody's business out there. A lot of times people ask, usually there's exemptions for if you have 15 employees or less and so on. However, in this particular case, Proposition 206 has to do with accrual of sick time for employees that starts basically July 1st, which we have to have policy ready to go by that time. So we'll tell you a little bit about our speaker. Our speaker is basically with Gallagher Kennedy. He deals a lot in the employment area law. In fact, I refer business over to him where clients who have employment issues they want to deal with. That's his exclusive area. And he deals in, just to give you some examples, employment discrimination, sexual harassment claims, wrongful discharge claims, breach of contract claims, wage and hour disputes. I could go on, but you can see that he is very well versed in the area of employment law, which is something that is important for all of us. He basically is a graduate of the College of William and Mary, and he's been with the Arizona Bar since 1987. He's also done some publishing of articles. He is also listed as the best lawyer in American employment law. So he, and I understand about 2/3 of his firm are listed as the best lawyers. Definitely someone with a lot of talent and skill that'd be helpful for us. He's also been on TV and also on the radio doing presentations on different various topics. I've known this fellow for a long time. He's helped us out. He's helped out a lot of our clients. So I'd like to welcome Don Johnsen.
Thanks very much, Chuck, and good day to all. We're here to talk about Proposition 206, which is something that most of you have probably heard about through one means or another. And if you're like a lot of the clients that I've been dealing with over the last few months, and particularly over the last couple of weeks about this, you're probably freaking out a little bit, and I'm here to try to assuage some of that for you. But I guess let me add to your anxiety a little bit by just giving you a little reminder. It's day after tomorrow, folks. This law goes into effect in Arizona on Saturday, July 1st. So we need to be sure that that we're all ready to implement that law as of this coming Saturday. Now, the good news is it's going to be easier than you may have heard. But won't try to sugarcoat it. There is some bad news in here, and we'll try to get through that together and get everyone to a point where they feel comfortable and confident in managing their own policies at their places of employment. Let's talk a little bit about who the law applies to. Well, it applies to almost everyone. The only workplaces that are exempt from this law are the state of Arizona and any federal employment workplaces. Everyone else, all private employers, all municipal employers, all political subdivisions, school districts, all of the rest of us are covered by this law, so we need to be aware of that. I want to mention that many people have heard that there is a small business exemption. Beware, there is no such exemption from the paid sick time law. There is a small business exemption from Arizona's minimum wage law, and that's what you may have heard about. Certain small businesses that meet certain defined parameters can be exempt from the state minimum wage law, not the federal law, but the state. But there's no small business exemption for this paid sick time law, so be careful about that. Which employees does the law cover? Well, it covers full-time people, part-time people, temporary people. In other words, it covers everybody. Anybody who's employed by your company is going to be eligible for paid sick time starting Saturday. So beware of that. I mention that because many of my clients have existing paid time off or vacation or sick leave policies that only apply to certain workers. For example, full-time workers or people who have been employed for X number of months or years. Those kinds of gradations in eligibility for this policy have to go out the window. Paid sick time now applies to everyone on the payroll at every company in Arizona. Let's talk about the accrual of paid sick time. Really, the formula is very easy. Under this statute, all employers, all employees are earning 1 hour of paid sick time for every 30 hours worked. Every 30 hours that somebody works, they are earning 1 hour of paid sick time under this statute. We've had a lot of we've had some confusion and some questions from a lot of sources over the last few months about part-time people. What if we have a worker who only works half-time, so they're only working, say, 20 hours a week? Well, that worker is earning paid sick time at the same rate as any full-time worker. That worker just earned, it takes a little longer for that employee to earn an hour of paid sick time than other workers do. But the rate remains the same for everybody. 30 hours worked equals 1 hour of paid sick time. The law accounts for the fact that many of us, of course, have exempt employees, salaried workers who are not covered by overtime under federal law. The law, and naturally, because they're not eligible for overtime, most of us don't record the hours worked for those individuals. Well, the law, paid sick time law, says that those employees are presumed to work 40 hours per week. So for all your salaried exempt workers, you're just going to accrue paid sick time for them at the rate of 40 hours per week. If we know that somebody's regular work week is less than 40, in that situation, they earn paid sick time on the basis of that lesser work schedule. This is just to account for the fact that, of course, some exempt employees may work less than 40, and the law doesn't want to necessarily grant them more time than they would really be earning. Everybody, so if they're working less than 40 on a regular basis, if that's their normal work week, then that's the rate at which they accrue. But otherwise, all exempt workers are earning at 40 per week. There are annual caps on the accrual and use of paid sick time under this statute. Those annual caps vary depending on the size of your workforce. As many of you may have heard, this ties into the small business dynamic that I mentioned earlier. A lot of people have heard there's a small business exemption. Well, not exactly, but businesses with fewer than 15 workers on the payroll, they're only required to provide 24 hours of paid sick time per year, or 3 days on an 8-hour day, of course. Everybody else, all businesses with 15 or more workers on the payroll, those businesses are required to provide at least 40 hours of paid sick time, or 1 week per year. So there is that difference between smaller and larger employees based on the number of people on your roster. Now, some of you may be wondering, well, if you're close to the line, 14, 13, 16 employees, how do I measure my workers? Well, the law tells us that we need to count all employees when deciding whether we have 15 or more. We have to count temporary, full-time, and part-time workers in deciding whether we have 15 or more. I mentioned in this slide, you'll see the question whether you use independent contractors or not. I flag that. That's a risk factor for many of you. If you currently use independent contractors or workers that you feel are independent contractors, you have to be very careful to make sure that they actually are independent contractors within the meanings of the proper IRS regulations and similar regulations. If you think they're independent contractors but they're really not, they're going to be considered employees, and now you're over the 15 employee limit, and that can have a negative consequence for you in the future under this paid sick time law. So beware if you're using any significant number of independent contractors in your workplace. If your number of employees fluctuates above and below 15 on the payroll, I'm not going to spend a whole lot of time on this because this is a fairly complicated analysis, but the law does lay out how we calculate the number of people on your payroll if it fluctuates above and below 15. My bottom line is if your roster does tend to fluctuate above and below 15, take a look at the statute, drill back into this slide, or call me or email me later if you like, and we can answer your question. My contact information will be on the screen later. A couple of other words about accrual of paid sick time. All employees begin accruing paid sick time under this statute on Saturday or on the date of their employment, whichever comes later. So everybody starts accruing when they start working or this coming Saturday. This includes new hires. New hires, anybody hired after July 1st, they start accruing paid sick time immediately. The silver lining is under the statute, we can require that they wait 90 days before using any accrued paid sick time, but they're earning it from day one. So we have to be cognizant of that. I mention that because that's another difference between the way many of my clients have operated their sick leave or paid time off policies in the past. It might be the norm for people not to be accruing any time off for, say, 3 months or 90 days or 6 months or even as long as a year. Under this statute, everybody starts accruing on day one. We can limit the new employee's use of paid sick time for 90 days if we want to. Paid sick time is accrued and used on a yearly basis. Employers get to choose what year you're going to use to calculate your accrual and use of paid sick time. You can use a fiscal year if you like. You can go calendar year. I've got many clients who are using employee anniversary dates. It's totally up to you. The statute allows you as the employer to make that choice. But one way or the other, we do need to define what our 12-month period is going to be for purpose of accrual and use of paid sick time. Paid sick time carries over from one year to the next under this statute. Under the law, employees may carry over a maximum of 40 hours of unused paid sick time, or 24 hours if we're talking about a workplace with fewer than 15 workers. So if I don't use any of my paid sick time at all during 12 months, presume I've got 40 hours there in the bank, all of that 40 hours carries over to the next year. However, that carryover does not undermine or affect the annual caps on the use of paid sick time. So no matter how many hours of paid sick time somebody might carry over from one year to the next, under the law, that employee is never entitled to use more than the annual cap in any one year. And that annual cap, again, is going to be 40 hours or 24 hours, depending on the size of your workplace. Some employers want to cash out workers for unused paid sick time at the end of the year. They do that as sort of an incentive to workers not to take the paid sick, not to take time off, and that's legitimate under this statute. However, there's a catch. If, in other words, we can cash out people for unused paid sick time, provided that we immediately credit that worker with his or her annual allotment of paid sick time for the following year, and that allotment is available at the beginning of the following year. So if you cash out a worker for their unused paid sick time bank on December 31st, you just have to make sure that that worker gets the full boat of 40 hours or 24 hours, as the case may be, as of January 1st. The law does not require that employers pay for any unused paid sick time. In other words, even though we've talked about carryover of unused time from one year to the next, and even though it's called paid sick time, well, payment doesn't necessarily apply at the end of one's employment. It's up to you as employers to decide whether you're going to pay for any unused paid sick time on separation of employment. I will say, as a risk factor, it's very important to make sure that whatever your decision is, you explain that in your written policies on paid sick time. What can employees use paid sick time for under this statute? Well, almost anything. That's the answer. The employee's own illness, injury, need for care, need for treatment, need for preventive care, perfectly okay for the employee to use time off to care for a family member who has any situation like that, to care for or an absence due to the closure of a business, due to a health emergency, the closure of a child's school because of a health emergency, someone who has a dangerous communicable disease, is to the time to care for somebody like that, an employee or family member. That's legitimate use also. One interesting component of the statute is that paid sick time also encompasses time off for domestic violence and related issues. The statute is very clear that if I need to take time off for any of these reasons, to get medical attention, counseling, even legal services due to domestic violence or stalking, those kinds of things, that's a permissible use of paid sick time. The law says we can use paid sick time for ourselves and for a family member. Well, who's a family member? The statute goes into great detail about who family members are. I prefer to look at it this way. Really, pretty much everyone. I would not want to, I think it would be pointless to get into an argument with a worker about whether any particular individual is too distant a relation to be considered a family member. The law is skewed toward allowing people to take time off when any family member is sick, and we need to recognize that. We've talked about 40 hours, 24 hours of accrual and use. The law does allow workers to use paid sick time in the smaller of hourly increments, or if the employer's payroll system uses a smaller amount of time to account for absences. In other words, if you account for employee absences in, say, 10-minute segments, 15 minutes, what have you, then employees can use paid sick time in those smaller increments. I've got a client that accounts for absences in 0.01 hour increments, and so they're going to be stuck with allowing workers to use paid sick time in that small increment. They're changing their policy, by the way. But hourly increments is going to be pretty standard. Let's talk about how employees are to tell you that they're going to need paid sick time. Well, the law, again, is skewed in favor of employees. The law mandates that paid sick time shall be provided upon an employee's request. And the law also says that employees may request paid sick time in any of these methods: orally, in writing, electronically, say email or even text, or by any other means acceptable to the employer. The law also says that when possible, the employee's request should include the expected duration of his or her absence. Well, if I'm an employee and I don't feel it's possible to tell you how long I'm going to be out, I don't need to tell you. All I need to do is request it, and under this law, you shall provide it to me. Now, the law does differentiate between a need for time off that's foreseeable versus not foreseeable, but it doesn't give us as employers much leverage, unfortunately. The law does say that if the need for paid sick time is foreseeable, the worker should make a good faith effort to give advance notice and should make a reasonable effort not to disrupt operations. The law also says that we can disseminate a written policy laying out specific procedures for notice, provided everybody gets a copy. So my sample policies, for example, talk about telephone or text or email notice within X number of hours of the employee's knowledge that he or she is going to need time off. But again, the law is skewed very heavily in favor of employees being able to take paid sick time. I will take a slight diversion here and try to reassure some people. The silver lining in this law is this. Even though we have the impression that employees are going to be able to use paid sick time very liberally whenever they want, for whatever purpose they want, well, remember, there's a cap. And once an employee uses his or her 40 hours, or 24 hours, as the case may be, depending on your workplace, remember that they're done. They've used it all up for that year. And if they are not wise enough to save that time for a legitimate purpose, well, that time is not going to be there when they do need it for a legitimate purpose. And that gives you leverage in trying to deal with absences that occur after somebody has already exhausted his or her legally protected paid sick time. So even though it's frustrating to have to give time in this liberal fashion, Once it's gone, and that gives the employer some added leverage. I'm not going to spend a lot of time on these issues. The law does give employees a lot of room to maneuver. I would tell my clients to be very careful, to be very cautious about denying anybody's request for paid sick time based upon the notion that we didn't get sufficient notice of it. My general tendency is going to be, look, go ahead and let them take the time and record the time, because now that time is gone and you're drawing down on that 40 hours or 24 hours, maybe even sooner than the employee might have thought. Documentation of absences, I want to mention this because the law does allow employers to require documentation that paid sick time was used for a permissible purpose under the statute. However, the law only allows us to do that when a paid sick time absence lasts 3 or more consecutive days. This is a big change for a lot of my clients. A lot of my clients have existing policies requiring documentation for almost any absence, and that sounds perfectly legitimate to you and me, I'm sure. Under this statute, we can only require documentation of an absence that lasts 3 or more consecutive days, so beware of requiring documentation for shorter absences. We have to be wary about the kind of documentation that we are requiring. The law is strict about prohibiting the disclosure of actual underlying information about somebody's illness, disability, medical condition, and about the further disclosure of any of that data as well. Some strict rules about that. Employers are also required to give notice to our workers of this new law. I will say that the basic obligation, and I've gotten a couple of calls over the last maybe 36 hours or so that I will phrase as emergency calls, people saying they just remembered Prop 206 goes into effect on Saturday. What's the bare minimum I have to do by midnight Friday? The bare minimum is to log on to the Arizona Industrial Commission website and find their model forms for paid sick time. There are 2 forms, one in English, one in Spanish. They're not big, just normal 8.5 by 11, and put those posters up on by midnight Friday or by the first shift on Saturday. That's the bare minimum of what you're required to do in terms of notification to employees. Just get those posters up right away on Saturday. This is what the poster looks like, the English version. Pretty easy to download it from the Industrial Commission website. We also have copies of this on my system at my office if you'd like. Other notice that we're required to provide, we have to start providing workers with notification of how much paid sick time they have available to them, how much they've used, and so on. You see on the screen some information that we are now required to provide either on our paychecks or stubs or on a separate attachment to a paycheck or stub. I've got some clients that their payroll systems are not set up to provide this data on the checks or the stubs, so they're just doing a half sheet separate showing paid sick time available, paid sick time used, and the pay received, and then just handing that to the workers with the paychecks. We have to keep records of all accrued and used paid sick time. We have to keep those records for 4 years. Most of you are familiar with record-keeping requirements under the Fair Labor Standards Act anyway, which requires that we keep payroll records, time worked and dollars paid, etc. So we need to build this accrual and use of paid sick time into our current record-keeping obligations as well. A few other additional concerns with respect to employer liability. Remember that if an employee is using an absence, or if an employee is taking an absence that's covered as paid sick time under this statute, it is absolutely illegal to count that absence against that worker under such things as no-fault attendance policies, things like that. I had a client yesterday that was working on a bonus policy that provides that a worker doesn't get a bonus if he or she has an absence in the last day of the week. And we're going to have to revise that policy because if that absence turns out to be a paid sick time absence, it's illegal for us to hold that absence against the worker. So we have to be wary of that. The law also contains a standard prohibition against retaliation against any worker for his or her use of any rights under the statute. Interestingly and dangerously, the law also includes a presumption that we have retaliated against any worker if there's any adverse employment action taken against that worker within 90 days of his or her use of any paid sick time. We can rebut that presumption if we show by clear and convincing evidence that we took the action for legitimate reasons, but we have to be very wary of taking any adverse action against someone because he or she, or within the last 90 days after his or her use of paid sick time. I'm recommending to a lot of my clients that they build in to any existing protocols for termination, build in a little caution flag or checkpoint. Has this individual used any paid sick time in the last 90 days? If the answer to that is yes, then go slow before terminating that individual. We need to make sure that we have clear and convincing evidence of a legitimate reason to terminate. The law includes a variety of penalties for record-keeping and notice violations, including the worst, I guess, is attorney fees and costs if the employee sues us and wins. As I'm sure you're not shocked to hear that when the employer wins a lawsuit, the employer does not automatically get attorney fees, just the employees. So the law is what it is. The law also provides that if we retaliate against a worker, for example, firing somebody because they've used paid sick time, the law also says that the worker is entitled to a penalty of not less than $150 for each day until his or her lawsuit reaches final judgment. Well, $150 a day, I mean, that's more than I'm carrying in my wallet right now, but it might not seem exorbitant. But just remember how long it takes your average court case to get to final judgment. That's a long time. That's $54,000 per year. Average lawsuit in Maricopa County takes a good 2 years to go from start to finish. So beware of this anti-retaliation provision. So let's ask ourselves again, are we ready to go into action day after tomorrow? Well, you're going to need to make some decisions for your workplace, and I've tried to itemize a few specific decisions that we think are most significant for this purpose. And we'll talk about each of them in turn. Integration of any existing policy into this new law, deciding how you'll handle accrual of paid time off, and what your year is going to be, and then how you're going to handle carryover. Let's talk about those real briefly. You do have the choice to integrate this paid sick time benefit into your existing, whatever existing policies you may have for vacation, sick leave, other paid time off. We have seen a trend over the last several years toward global PTO policies, employers who just throw out a number of hours or days that everybody's entitled to earn or have, and they can use it for any purpose they want. That's perfectly fine and a perfectly legitimate management decision. Just need to beware that including paid sick time in such an existing policy means that we have to let workers use all of that paid time off for purposes, for the broad purposes allowed under the paid sick time statute. We also have to be wary of that restriction on documentation that we talked about earlier. We can only require documentation of paid sick time absences that last more than last three consecutive days or more. So there's some risk in integrating this paid sick time into your existing policy. Many other clients are deciding to go with a standalone paid sick time policy. They're going to keep their existing PTO policy as it is, and they're just going to carve out this separate little PST bucket over here on this side and manage it separately. That is inconsistent with the global PTO concept, and so there's that. But it does allow for more accurate tracking of the accrual and use of paid time off. It also reduces some of the risk in the case of a claim of retaliation. In other words, by segregating the paid sick time concept from other paid time off policies, you can reduce the opportunity for somebody to say they were discriminated against or retaliated against because they use that paid sick time. Another key decision is how to accrue paid sick time. Many employers want to allow people to accrue paid sick time only as they actually work it, accrue as earned. That's the headaches with that. We have to track it, obviously, and we have to report it, and it's going to vary on each paycheck. So there's some administrative burdens in that. We also have to make sure that we're calculating and reporting correctly. The other option is to just credit workers with their full paid sick time entitlement at the beginning of the year. In other words, tell my workers, I'm not going to track how much you work or accrue paid sick time. I'm just going to give you your 24 hours of paid sick time right on day one. So much less of an administrative burden there. The downside is by giving someone their 24 or 40 hours of paid sick time at the beginning of the year, you always run the risk that that worker ends up taking some time that he or she might not otherwise have earned. I had a client ask me yesterday, so I give this guy 40 hours on day one, he takes 5 days on day 2, and then quits on day 7. That's legit? And I said, well, yep, that could work. That would be legal. So that's a risk for some businesses. The next decision is just what year you're going to use for purposes of tracking of accrual and use of paid sick time. As I mentioned earlier, you can use any of these variables: calendar year, anniversary, fiscal. Many of your larger entities, people with 50 or more workers, are covered by the Family Medical Leave Act, and so you may be familiar with the rolling 12-month method, which just looks backward 12 months from the date of anybody's time off and determines how much time they have used in that 12 months, and whatever's left, that's how much they have at this moment. You really get to pick and choose the method that works best for you. The last I'll mention is how are we going to deal with unused paid sick time? Are we going to let people carry it over from one year to the next, or are we going to cash them out for their unused paid sick time and then credit them with the full boat of time that they would get for the following year? Those are options for you, and you get to make that policy decision. We also need to decide how we're going to handle payment for unused time on separation of employment. As I mentioned earlier, the law does not require that people get paid for unused sick time at the end of employment, but whatever your decision is on that, you need to be explicit about it. We need to be clear in our policy about whether or not we're going to get paid. So those are the key decisions that I encourage all of my clients to make. They're important decisions, but they're pretty easy for most business owners and managers to make if you think about it. And then, again, getting the language in place is not going to be a big problem for most workplaces. As I mentioned, the bare minimum requirement is just to put the posters up. Then you'll want to have a written policy that addresses all of these issues that your employees can read and understand and that you can apply in the future. We've been involved over the last several months in working with clients in developing their own policies, and of course we have standard sample policies available for webinar participants just in nature of our, in courtesy of our relationship with Chuck and his company. So those are some key decisions, what you need to know from my perspective about paid sick time. And so with that, I will turn it over to Chuck, and I'll take questions.
Okay, Don, thank you so much. By the way, Don, I would think some people are going to want to contact you, and I'm looking at that right now. Your number is 602-530-8437. I've already been on the phone with Don about 4 times on this topic just myself already. Or you can send him an email, and you see that in the slide, but since you don't have the slides for printouts, dpj@gknet.com. So make use of that. And are you working on Saturdays?
I'm working this Saturday, that's for sure.
Okay.
I also will mention, Chuck, and to the participants, if you do call or email, just remind me that you are a participant in the webinar today, and I'd be happy to answer your quick questions just gratis. That's no problem. And if you need more help with something, then certainly we can talk about how to handle that.
Right. Okay, at this point we're going to have some typed in questions here, and we're going to turn off the recording. We found sometimes people don't really want us to read their questions and have it be recorded. So at this point, Kit, do we have the recording turned off?